What happens when a Supreme Court justice's carefully worded response sends chills down the spine of a television host? The answer might reveal more about our constitutional safeguards than we're comfortable admitting. Sunny Hostin, a prominent co-host of ABC's The View, recently shared her deep unease following an on-air conversation with Supreme Court Justice Sonia Sotomayor. The discussion centered around a question that has been gaining traction in political circles: whether President Donald Trump could constitutionally pursue a third presidential term. During Tuesday's broadcast of The View Behind the Table podcast, Hostin didn't mince words about her reaction to Sotomayor's response. "It scared me," she stated plainly, describing how the justice's measured legal analysis left her feeling unsettled about potential constitutional challenges ahead. The conversation that sparked Hostin's concern took place during Sotomayor's appearance on the daytime talk show. Co-host Alyssa Farah Griffin posed a direct question about Trump's hints regarding a potential third term, asking whether such a move would be constitutionally viable given the 22nd Amendment's clear prohibition. But here's where it gets controversial. Sotomayor's answer wasn't the definitive "absolutely not" that many might expect from a Supreme Court justice. "The Constitution is settled law," Sotomayor explained during the interview. "No one has tried to challenge that. Until somebody tries, you don't know. So it's not settled because we don't have a court case about that issue. But it is in the Constitution, and one should understand that there's nothing that is the greater law in the United States than the Constitution of the United States." This nuanced legal perspective, acknowledging that constitutional provisions remain untested until challenged in court, is precisely what troubled Hostin. The co-host elaborated on her concerns during the podcast, explaining that Sotomayor's emphasis on the amendment never being tested felt ominous given the current political climate. Supreme Court justices are usually very reluctant and guarded to say they don't say much, and her answer, I think, in particular to whether or not Donald Trump would seek a third term, even though the 22nd Amendment of the Constitution prevents that, was. Hostin began, before fellow co-host Joy Behar interjected. "Was vague?" Behar asked. "No, it wasn't vague. I thought it was pretty clear. She said it hadn't been tested yet. There's no case," Hostin clarified. And this is the part most people miss: the distinction between constitutional text and judicial precedent. While the 22nd Amendment explicitly states that no person shall be elected to the office of president more than twice, Sotomayor's point highlights a fundamental aspect of American jurisprudence. Constitutional provisions gain their full interpretive weight through court challenges and judicial review. Trump himself has been anything but subtle about his interest in extending his presidency beyond the traditional two-term limit. In a March 2025 phone interview with NBC News, he declared he was not joking about the possibility of seeking a third term. "A lot of people want me to do it," Trump told the outlet, adding, "But I basically tell them we have a long way to go, it's very early in the administration." Behar added her own perspective to the podcast discussion, suggesting that Trump's pattern of challenging established norms makes Sotomayor's cautious legal analysis particularly relevant. Anything that he does that overwhelms or overtakes anything that's in the Constitution, because he doesn't follow the rules. And it hasn't been done before. No one has done any of the things that he has done, she observed. What makes this exchange particularly significant is Sotomayor's careful choice of words. "One should understand," rather than "one must understand," when referring to the Constitution's supremacy. This subtle linguistic distinction, which clearly didn't escape Hostin's attention, suggests even a liberal justice recognizes the theoretical possibility of constitutional challenges that could test established interpretations. The broader implications of this discussion extend far beyond partisan politics. Sotomayor's response illuminates a crucial tension in American constitutional law: the difference between what the Constitution says and how courts might interpret unprecedented challenges to its provisions. For legal scholars and constitutional experts, Sotomayor's measured response reflects sound judicial reasoning. For television hosts and political commentators like Hostin, however, such careful legal language in the face of unprecedented political circumstances understandably provokes anxiety about democratic institutions. The question that emerges from this exchange is whether Hostin's fear is justified or whether Sotomayor's response simply reflects the responsible caution expected from a Supreme Court justice when discussing hypothetical constitutional scenarios. Here's the controversial reality. Could a determined challenge to the 22nd Amendment's interpretation actually succeed in court? While most constitutional scholars would argue such a challenge would fail decisively, Sotomayor's acknowledgement that it remains untested suggests even she wouldn't completely dismiss the possibility of creative legal arguments. What do you think? Was Hostin right to be scared by Sotomayor's response? Or does the justice's careful legal reasoning actually strengthen our constitutional protections? Should Supreme Court justices provide more definitive answers about constitutional provisions, even in hypothetical scenarios? Share your thoughts and let us know whether you believe Sotomayor's measured approach was reassuring or concerning in these unprecedented political times.